and administrative processes involved in the delivery of RDP houses. And what we did was to consider issues relating to procurement.
Strong earnings reports, while there was little reaction from news that factory output fell in September from the
benefits due to the RDP housing projects to commence, and the issues relating to contractors where there's delay also to finish the houses which were built. Allocation of RDP houses, the issue was raised under this heading related to unintended beneficiaries, allegations of removal or changing names of beneficiaries who were on the list, and complaints relating to undue delays to allocate the houses to the beneficiaries. So all this was done in all the 9 provinces. There were also problems relating to post-allocation problems, delays in issuing of title deeds, and what we recommended to the Minister of Human Settlements was as follows. As far as planning is concerned, the state should consider establishing a compliance monitoring divisions to ensure that the required processes are complied with before implementation of the RDP projects. So in this instance, there was clear lack of planning. On procurement, the aforementioned compliance monitoring divisions should also be tasked with monitoring compliance with prescripts in the procurement of RDP houses. Allocation, so the government should consider putting in place plans with clear time frames to prioritize adjudication of RDP houses. And post-allocation, the state should, through happy letters, advise beneficiaries on the process to be followed where structural defects are discovered after handing over the RDP houses. And on title deeds, we said the state should develop and adopt a strategy with clear time frames on how to eradicate the existing backlog in the issuing of title deeds. I must indicate that as the public protector, we also assisted the Department of Health and Human Settlements to establish Ombudsman offices where then people can complain to those institutions directly. That is assisting the public protector to then focus on other complaints. And we also have an MOU with the Health Ombudsman, and we're working on one with the Human Settlements Ombudsman. I must indicate, though, that we still receive complaints relating to RDP-related complaints and health-related complaints, though we work closely with those 2 ombudsman offices. So the reports which are issued in terms of the Constitution, Section 182, subsection 5, are as follows. The Kamanyane report, I investigated allegations of failure by Dr. Ruth Sokhomotsi Mompati District Municipality, formerly known as Bopirima District Municipality in the Northwest, to submit the names of 26 former employees of the municipality to the Cape Joint Retirement Fund for purposes of receiving additional benefits subsequent to their transfer to the Provincial Department of Public Works and Roads in July 2001. So this complaint was received in 2015 from these 26 affected complainants. They allege that they suffered prejudice as a result or the conduct of the municipality. Having considered the evidence which we then uncovered that during the preliminary investigation, I have decided to resolve the matter through mediation and conciliation, and we signed a settlement agreement which was facilitated between my office and the complainants, which was also signed with the municipality. So in terms of the agreement, the municipal manager is to effect payment to all 26 complainants in accordance with clause 2.1 of the settlement agreement signed between Dr. Ruth Sokhomotsi Municipality and the complainants on 26th of August 2018. And further, the municipal manager within 30 days of publication of this report, should identify all the other affected employees, because there might be more other employees, and as well compensate them. And further, the municipal manager must within 15 days determine the benefits payable to all employees or former employees, pays 60% of each member's gross benefits from the Cape Joint Consolidated Retirement Fund, plus the 15.5 interest therein. The second report relates to DHEMO, which I investigated. It also relates to the Northwest Provincial Department of Public Works and Roads to transfer the house to her, which she procured. This relates to a 71-year-old pensioner who lodged a complaint in 2012. So it's also part of the cases which we've delayed to finalize. So she alleged that she approached the department in 2008 and offered to purchase the property. She paid an amount of 112,000, and after paying that amount, she further was requested to pay 3,400 as transfer costs to the state attorney. In 2009, she was advised to pay again an additional occupational rent per month until the property is registered into her name. So she was not allowed to alter or extend the property until it was transferred into her name. To date, the department has allegedly failed to transfer the said property into her name. This was resolved by the office, where we then had a finding that the department failed to register and transfer ownership of the property into the complainant's name. And the following were the findings: that the head of department must within 30 days from date of publication of this report provide the Office of the State Attorney with all the necessary documents to enable State Attorney to register and transfer ownership of the house into the complainant's name. That the State Attorney must, upon receipt of those documents, register the property into her name, and further that the head of department must refund the complainant all those 200 rents which she was paying since 2009, and must stop charging the occupational rent accordingly, and the HOD must within 30 days from date of publication of this report send an apology letter to the complainant for the undue delay of the transfer of ownership. So the next report relates to Mr. Chester Staples. This is an investigation relating to the failure by the Northwest Provincial Department again of Local Government and Human Settlements through its Northwest Development Tribunal process, where an application was lodged by the complainant for the establishment of a development area at a farm near Rustenburg in the Northwest Province. The complaint was lodged in 2013 by Mr. Chester Staples, where he alleged that he is a property developer, and in 2009 he approached a town planner around Northwest to submit an application on his behalf, seeking permission to establish a development area on portion 31 and the remaining extent of portion 3 in this farm. So the project was to be known as Chesterton Equestrian Estate. The application was submitted in 2009, and the tribunal preliminary hearing conference to process the application was supposed to take place in 2010. The matter was postponed further, and until 2011, the hearing finally didn't take place. This matter was due to failure by the department to finalize the process to nominate and recommend to the Premier the appointment of the new tribunal members after the first tribunal's term of office had elapsed. So The consequence was that the complainant lost an amount of about 1.3 million, which included fees to the town planners who submitted the application on his behalf. And I found the allegation that the department, through its tribunal, failed to process the complainant's application for the development of a property to be substantiated. I found that the complainant was prejudiced by the conduct of the department. As a result, I directed the HOD that must, within 30 days of the publication, issue a letter of apology, and further, the HOD must pay the complainant an amount of 1.3 million plus interest calculated from the date on which the application was lodged. And the HOD should then institute civil proceedings against any official or officials who were responsible for such delay. The next report relates to Mr. Komu. This is also relating to the undue delay to pay for services rendered and maladministration by the Northwest Provincial Government relating to improper termination of a contract with RR Travel JP Tsepi Investment. This followed a complaint by Mr. Komu on behalf and in his capacity as the director of this company. Again, this complaint dates back to 2015. So Mr. Komu alleged that in 2013, the company was awarded a transversal contract for a period of 2 years, dating back to 2014, and was expiring in 2016 for the provision of specialized travel and hotel accommodation services to the Northwest Provincial Government. So the aforementioned service included advising the provincial government on the best possible traveling arrangements, destinations, accommodation routes, and etc. So the parties entered into a contract and they signed an LSLA. As early as 2014, he began experiencing problems with the receiving payments from the department, and he raised a complaint with the department to no assistance. And in addition, the department allegedly improperly terminated the contract, and they owed him an amount of around 10 million for services rendered between April 2014 and August 2016. So the Northwest Provincial Government also owes him interest that had accrued as a result of late payments. I found that the allegation by the Northwest Provincial Government to pay, or the delay to pay the company, was substantiated, and further that the allegation that the Northwest improperly terminated the contract was unsubstantiated. Based on my finding that the Northwest unduly delayed to pay the company, there is a prima facie evidence that indeed there may be some interest which is due and payable to the company on those invoices which were not paid on time. And I found that the allegation that the complainant was prejudiced by this due to the delay was substantiated. So the remedy was that the department should also issue an apology to the complainant, and the Director General should issue this, after issuance of this report, appoint an audit company to audit all the invoices and supporting documents to independently determine the interest payable to the company. And I must indicate that we've resolved through the alternative dispute resolution during the investigation, where the government or the department agreed to pay the 10 million which was owed to the complainant. So now the remaining part is the issue of the interest. The next investigation relates to the South African Local Authority Pension Fund. And this complaint is failure, it's allegations of failure by the South African Police Service to timeously submit disability claims in accordance with the rules of the South African Local Authorities Pension Fund, which is called SALA Pension Fund, thus financially prejudicing the complainants. My office received complaints from 7 complainants, all employees of SABC and members of the SALA Pension Fund. The complainants allege that SABC failed to submit disability and death claims to SALA in terms of the SALA Pension Fund master policy. The late submission resulted in claims being repudiated by SALA Pension Fund. As a result of the late submission of claims and subsequent repudiation, the members of the SALA Pension Fund suffered financial prejudice, and in that they did not receive compensation they are entitled to in terms of the master policy. In this matter as well, I must indicate that during the investigation, we also had an alternative dispute resolution where SABC agreed to pay the affected complainants. And the findings in this report was that the National Commissioner of Police needed to issue a letter of apology to the complainants, and also SABC should pay the following amounts to the affected complainants. There was the first complainant, Mr. Sijake, it was nearly R1 million. The second one, Mr. Makaba, it was around 600,000. The third one, Mr. Lomo, it was around 1.3. And the fourth one, Mr. Mashiko, around 1.4 million. And the fifth one, Mr. Nyokong, an amount of 1.7 million. And the sixth one, say Teko, just over R1 million. And then pay interest at the prescribed rate of interest prescribed in terms of the Prescribed Rate of Interest Act to the complainants on this amount from date of this report. I must indicate that this matter was also raised in the Free State by one of the journalists, Tuso, who was also receiving a lot of complaints from widows of the members of SABC. So some of them will also benefit from this particular report. So the Minister of Police was ordered to make sure that all employees are compensated and that there's standard operating procedures for handling such disabilities. There's no more delay by SABC to submit the claims to SALA so that the payments are paid on time. The next report relates to the Northwest Housing Corporation and the City of Tshwane. It's an allegation of maladministration again by Northwest Housing Corporation this time, and the City of Tshwane Metropolitan Municipality regarding the improprieties relating to the sales and transfer of properties that belong to the Northwest Housing Corporation, falling within the municipal boundaries of the City of Tshwane. This complaint was lodged during 2011-2013 respectively by all the complainants. The allegation that the city and the corporation improperly failed to assist the complainants to register and transfer the stands into their names, where the stands were around Garankuwa, Mabopane, in fact 3 of them around Garankuwa and 1 in Mabopane respectively. That complaint, my finding was that was substantiated. I directed the Gauteng MEC for Human Settlements to take cognizance of the report, and within 60 days from issue of this report, appoint an audit firm to investigate if there are any other persons who have been deprived of their property, and within 30 days of the finalization of that process, to make sure that the remedial action is implemented. The next finding was that include in his oversight role with the housing and human settlements activities the monitoring of implementation of the remedial action taken. I directed the executive mayor of the City of Tshwane within 90 days from the date of the issuing of this report to provide alternative houses having all the necessary basic services such as water, electricity, sewage system to all the beneficiaries who were dispossessed of their housing rights through the alleged fraudulent and unlawful transfer of their properties, or compensate the complainants with the current market value of the properties that were fraudulently transferred. And within 90 days from, in fact, of the report from the MEC for Gauteng, ensure that the city provides alternative housing, because the MEC will have to conduct that audit, and then if there are additional names, those names should also be compensated. And the city of Tshwane should ensure that within 90 days from the date of issuance of this report, establish a township at the area where stand number 2827 zone 2 Garakua is situated, and register and transfer the relevant property to one Mr. Mier. Ensure further that they implement the investigation report and further issue an apology to the deprived complainants. Also, this matter, I requested that they should report this to the police, especially where the officials who were involved within the city of Tshwane and the Northwest Housing Corporation, to be reported to the police, so that an issue of or the crime or fraudulent crime can be investigated. The collapse of governance at Pikitup. This is another report. I investigated allegations of maladministration and violation of the waste management service provider to the city of Johannesburg, Pikitup's supply chain management processes and procedures in connection with the awarding and subsequent extension of the contract to Aqua Transport and Plant Hire. The investigation also covered alleged irregular procurement of office space to relocate Pikitup head office, appointment of consultants, appointment and removal and replacement of employees in violation of the Pikitup recruitment and selection policies, and payroll and misconduct arising from theft of Pikitup cellular telephones. This probe was prompted by complaints received from Philip Richardson in August 2013 and the South African Municipal Workers Union in 2016. So Mr. Richardson alleged that the contract was awarded to Aqua by Pikitup, was observed as being under investigation, and yet was progressing normally with payments being made to the service providers. Since public funds were invoked, it appeared to Mr. Richardson that both Pikitup and Aqua considered themselves totally above the construct of due process, and they believe that they can act with impunity. And there were media reports relating to this matter when Mr. Richardson raised the complaint. Some also, on the other hand, alleged that in their complaint that Ms. Ne extended the contract of Aqua and added 40 million despite a decision by the previous board not to extend it. That she irregularly appointed friends and former colleagues without subjecting them to an interview process, and improperly offered them higher salary scales than the normal remuneration scales as prescribed by the Pikitup remuneration policy. The union further alleged that the friends and former colleagues appointed improperly and offered higher salaries. Scales were Mr. Nganana, Ms. Pumla Mukele, Mr. Ngwenya, Ms. Docrat, Ms. Alexander, Mr. Sampson, Mr. Boysen, Mr. Dennison, and Mrs. David. It was further alleged that Mr. Ngwenya, who is the son of Ms. Nie's domestic worker.
Okay, so we come out of that briefing being held by the Public Protector Busisiwe Nkhwebane, and we proceed with our show.